Gang Quickie. If you're talking about speech regarding advocacy of illegal activity, it's still fine as long as it doesn't pass the Brandenburg test of imminent lawless action. Jeffrey Dean McCoy was arrested for giving 2 speeches to a California street gang, and he was convicted and sentenced to 15 years. The Arizona Court of Appeals affirmed the conviction, and the Arizona Supreme Court denied review. So he appealed in U.S. District Court. The federal court ruled in his favor, saying, while it may have been incredibly stupid and short-sighted for McCoy to have offered his opinions and experiences to a group of teenage gangster wannabes, the Constitution protects even stupid speech. Terry L. Stewart, director of the Arizona Department of Corrections, appealed to the Ninth Circuit. The Ninth Circuit said that McCoy was charged, tried, and convicted based solely on his speech and association, both First Amendment rights. But they noted that the state court decision had to be, quote, contrary to or involved an unreasonable application of clearly established federal law as defined by the Supreme Court. And it doesn't pass the Brandenburg test because the Brandenburg decision itself said that the mere abstract teaching of force and violence is protected by the First Amendment unless it is, quote, directed to inciting or producing imminent lawless action and is likely to incite or produce such action. And an abstract advocacy of criminal action at some unspecified time in the future just doesn't qualify. That was what the Supreme Court had said in Hess v. Indiana, ruling that, quote, advocacy of illegal action at some indefinite future time is not sufficient to permit the state to punish speech. Stewart appealed to the Supreme Court, but they denied certiorari, meaning the Ninth Circuit's ruling stands and they had to let McCoy go. But remember, the First Amendment isn't just about speech, it's about association too. So the Ninth Circuit also ruled, indeed, McCoy's conviction strays dangerously close to a finding of guilt by association. Such a conviction, even in the context of a street gang, cannot be squared with the First Amendment, and thus cannot stand. Using speech and association to go after someone is absolutely not allowed in this country under the First Amendment. One day, lower courts will finally get the message.